The question is that who is accomplice and what is evidentiary value of his evidence. Now, why we are raising this question? This is of immense importance. If you see the scheme of this Indian Evidence Act, आप यदि इंडियन एविडेंस एक्ट को देखें ध्यान से, तो इंडियन एविडेंस एक्ट बेसिकली टॉक्स अबाउट three primary things. One, it says by which fact you will prove something. So basically it says relevant fact. First part is covered. How will you bring those facts? So second part, by medium of evidence, oral, documentary. So this is covered. Now the third part says, how will you prove these facts and who will prove these facts? How and who? So within this, we discuss burden of proof. Who has burden of proof? On this burden of proof, I hope many of you might be aware. You must have read criminal procedure, you must have read civil procedure. So if you see criminal procedure, it is always general rule that prosecution will prove first. He will establish the case, prosecution will establish the case, and then sifting burden that you have to see in CRPC. And as far as CPC is concerned, now you can see in CPC also, I hope Order 18 deals with this question of examination of witness, etc., which is part of this discussion also. Now, and in that discussion, it is written that generally again it is plaintiff who has the right to begin, but it can be other way around also. Their defendant can also begin. I will not divert much, but just informed you and how this topic comes here in this picture. What is the context? So burden of proof you know already, you might have read. We are not concerned with this question right now. Now how this accomplice comes in this picture. So you said how will you prove and who will prove. So who will prove it obviously will involve witness. Witness has to prove by direct evidence, indirect evidence, oral evidence, documentary evidence, various kind of evidence you will bring here and there. That we'll discuss in examination chapter. But here we are concerned with the question of who will be the witness. So the question is, can an accomplice be a competent witness? The answer is obvious in section 133. I hope there is no confusion on this point. Section 133 in categorical word says, an accomplice shall be a competent witness. It doesn't say maybe or is or, it says emphatically, shall be a competent witness against an accused person. That's very clear. So accomplice is a competent witness. But competency is not the only issue to be decided in evidence law. If you have little bit knowledge of evidence law, you know that competency is not the only question. A person may be competent, but he may not be truthful, he may not be credible. So credibility of witness, that is credibility of person, and even a person may be credible, but his version may not be. Many people speak things keeping interest in their mind. We witness many such situations. Only 2 days back I was in a meeting and there I saw around 60 plus or 65-year person speaking very biased. Because he might have something in his mind. He is by profession an accountant, so he may have something in his mind. The person for whom he was speaking, maybe his client, so he was really biased in his opinion. That was prima facie clear. Why I brought this illustration? It is just for the reason that you should never confuse credibility of person with credibility of virgin. I'm using two words with emphasis: person and virgin. So, accomplice is credible witness or not? This is one question. And whether his virgin is credible or not is another question. I don't know how many courts have applied their mind to this particular point, because we focus mostly on first point, that whether accomplice is competent witness or not. So I think that I have made picture clear before you. And for the students of law and for those persons who are practicing law, it may be another interesting question. That C133 has got two parts. In first, you said competent witness, clear. Stephen has made it very clear. But in the second part, he says that now why he wrote that a conviction is not illegal merely because it proceeds upon uncorroborated testimony of an accomplice. So his emphasis seems to be on this point, that conviction does not become illegal merely due to this reason, that it is accomplice evidence and there is no corroboration. So uncorroborated testimony of accomplice can be a ground for conviction. It says not illegal merely because this. Now, what is the import of this particular clause? What is the intention behind this profound expression made by that great jurist James Stephen? Why he said this? That conviction, he proclaimed he is a competent witness. So competency is not a question at all. Credibility remains. Competency is not in question, credibility is in question. So it says conviction is not illegal merely because it is based on uncorroborated testimony. Uncorroborated testimony of accomplice. Agreed, got the point. I do not entertain any confusion in my mind, and you should not. Competency is clear. Conviction can also be had on the sole basis of uncorroborated testimony of accomplice. That is what is hinted here. Not illegal, merely because. Now, there may be possibility that accomplice may be credible and his virgin may also be credible. And there are persons who can be pious, pure, and their virgins are full of veracity. I can't say that as a rule that accomplice is always untruthful. And that is what is his submission. That is what I understand by reading this section 133. Then there is another relevant provision, section 114b, which is brought to kind attention of everyone, and that is what the court examiner, everyone does. Whenever you read cases, even decision of Supreme Court, they bring 114b. But the fact of matter is 114b deals with presumption. It is not dealing with the competency question. 133 is competency question. So primarily there is no such confusion and contradiction which is generally projected. I don't see it. Different people may have different understanding. But what 114b says, that is also relevant to see here at this juncture. That is how we can proceed further. Otherwise, you will remain confused, because that is how you or we have been trained and have been taught. An accomplice is unworthy of credit. It says accomplice is unworthy. See, accomplice is unworthy. So being unworthy and being incompetent are two different situations. Accomplice is unworthy of credit. If you ask me a question, am I competent? I will say yes, everybody is competent. See, everybody is born to succeed. Everybody, without any doubt. But this sense of belief is in some people. This sense of confidence is in some people. It happens with you as well. An accomplice is unworthy of credit. So this is a question of credibility, not competency. So these are two different dimensions. But people always project that there is contradiction. So I have made my point clear at the outset that I fail to understand how there is contradiction. I seriously speaking, I do not appreciate that point. Unworthy of credit unless he is corroborated. So what it requires? It raises a presumption of unworthiness of credit and says that you bring corroborated or corroboration to make his evidence stand. So what is the submission in 114b? That accomplice evidence may not stand on its own. So it needs corroboration because he is unworthy of credit, and this is presumption, mind you. The moment I say it is presumption, I must make it very clear because I hope that the people listening to me will very clearly appreciate that presumption is based on general understanding. If there is a clear proof against presumption, then presumption dies down. This is just a presumption. If I can prove that accomplice is worthy of credit, no corroboration is required. But this is very difficult to prove. There is inherent improbability that accomplice will be or will not be interested party. He is an interested party. So accomplice can be considered always credible, that is questionable. He has been co-accused, he has committed the crime together. He may be saving his face, he wants to become approver. Now in this context, it is very important to know, and especially the young lawyers and the students generally ask this question. It may be about the stage which is different. Accomplice is also a co-accused, there is no doubt. And this accomplice becomes a approver, there is no doubt. Like culpable homicide becomes murder and agreement becomes contract, and you use them interchangeably. So accomplice can be approver when he is granted pardon. And he is granted pardon because he is the best person who can give evidence. 306 is based on this understanding that he is one of the best witness which the court may have and which the prosecution may have. Because he is involved in the crime, he is participus criminis, he is partner in the crime. He has acted the role of principal and agent in the crime. So who can be best to tell you that what happened in that crime and who committed it? It says also in 306, and 306 talks of tender of pardon to accomplice. The words are used there. With a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offence to which this section applies. The CJM or MM at any stage of investigation or inquiry or trial, at any stage, see, the horizon is very broad. And the magistrate of first class inquiring into at any stage of inquiry or trial may tender a pardon to such a person on condition of making a full and true disclosure of the whole of circumstance. So if he is ready and willing to make true and whole disclosure of the circumstances within his knowledge relating to the offence, and to the person concerned, whether as principal or abettor, then he can be granted this. But mind you, it is not in all offences that he is given this pardon. It is only in serious offences. If you read this 306 carefully, you will understand this. In CRPC, that offence triable by session court, court of a special judge, offence punishable with imprisonment which may extend to 7 years or with more severe punishment. There is reason behind that, that in offences involving severity and in severe grave offences where severe punishment can be granted, it is more likelihood that the people will run away and you will not get the evidence and they will be very smart. And I have written on this point. So you may require a person to be best witness in such cases so that conviction can be had. And especially in India where conviction rate is very, very poor. So it applies only in few offences. You just see this, you will inform yourself. Power to direct tender a pardon in 307. So now, who is accomplice? Accomplice is a person who has been participus criminis. Either he has been involved in the crime directly or indirectly. He is party or privy to the crime and he becomes approver when he is granted pardon. So accomplice becomes approver at the stage when pardon is granted to him. The condition is that there should be true and full disclosure of the circumstances of the crime and of the criminals which he know. He is required to divulge that. Be very careful on this point. So you understand little bit who is approver. Now who is accused, co-accused? Accused is any person, and there is no such definition of accused, co-accused in CRPC or evidence law, etc. I think. So when we see the dictionary of law, we find that co-accused means any person who has been involved in the commission of crime with somebody else. One of two or more people or organization accused of the same crime. Co-accused. One of two or more people who are accused of the same crime. Who are accused of the same crime. Co-accused. And if you see Evidence Act, you find a reference of co-accused in section 30. You have found a reference of accomplice in 114B and 133 just now. You have seen this. Now, when you visit section 30, which is related to this co-accused, then you find only reference that in case of joint trial, confession of one co-accused may be relevant against another. If they are being tried in joint trial for the same offense. They do not talk much. They do not say much. They do not talk much, they do not say much. We have not written in this chapter of witness that co-accused will be a competent witness. We are saying that the accomplice will be a competent witness. So this is now basically not the difference of substance as such. But as these are different words and used at different stages. Approver is one who is granted pardon, so you understand. Accomplice can become approver. I have written some points of distinction just for convenience that approver, you can say, accomplice is genus, approver is species. Accomplice is genus, approver is species. An accomplice who is granted pardon is approver. So approver will be accomplice, but all accomplice will not be approver. Be careful. If you see this chapter of witnesses, you mention accomplice. And witnesses are administered oath. as per Oaths Act 1969. There is provision of administration of oath. When you depose before the court, you will be administered oath. So accomplice will be administered oath. But when I see co-accused, he is referred only in this section 30 in the scheme of Indian Evidence Act. And I do not find any such reference there. It says, when more person than one are being tried jointly for the same offence, court may take into consideration such confession. And confession is not on oath. Confession is never on oath. So accomplice is administered oath, whereas co-accused is not administered oath. If somebody is confessing, where is the need of oath? Why I will confess the guilt against myself? (164) CRPC you might have read, you might be aware. And you know, confession is, you see the scheme of CRPC, 164 very clearly says at what stage confession will be recorded. I hope everybody is aware of this fact that it is during trial. Now see, accomplice stage is a stage, now during inquiry, I said wrongly, I had in my mind investigation and not during trial. So confession is in section 164 CRPC. When you see confession, it is during investigation. It is during investigation, that is before trial. Before trial. Those who have not seen that, they can see 164 and they can understand that is before trial. We have not reached to the court. But accomplice is a competent witness. And this competent witness is administered oath during trial. And you see the position of 133. It is written in chapter 9, as I have drawn your attention earlier as well. And see the position of confession of co-accused, it is written in relevant fact. So I said confession is not on oath, whereas this accomplice evidence is on oath. This is how we bring about certain distinctions, fine distinctions, in which generally people are interested. See, furthermore, confession of co-accused is very weak kind of evidence. And no evidence at all, in a sense. You read Bhuvani Sahu. And one of the reasons is that you are confessing the guilt against other also. Confession of co-accused. If it is against my interest, it is good evidence. But if I am speaking against somebody else also, that is confession of co-accused, it is not so sacrosanct. And it has very little value because it may not be believed because the person never owed this confession. A and B committing crime and A accepting, A giving confession against B also, which B has never owed up. Obviously, it will be weak against B. Obviously, it will be weak against B. So, I hope I have given you a little bit idea of co-accused and accomplice and approver. Because this question comes up in your mind and in anybody's mind time and again. So, be careful about these words. Now, coming back to the point of this controversy which is generally raised, I said there are two issues and I clarified that one is of competency and another is of credibility. Now, and I have drawn your attention towards this 133 and this 114B. If I see the view of, now I hope prima facie everybody understand what 133 says. 133 says accomplice is a competent witness, no doubt. So number one clarification is that he is a competent witness, there can be no doubt about it. Competency of witness is one issue. And then it only says that conviction is not illegal merely because it proceeds upon the uncorroborated testimony of accomplice. So even uncorroborated testimony can be relied upon, but if you see the approach of the court, they have developed a rule of caution always that we will not rely upon uncorroborated testimony of accomplice. But that is not rule of law, that is rule of prudence. You can see that in many cases, I have in my hand this case here. This is Francis Stanley versus Intelligence Officer, Narcotic Control Bureau, Thiruvananthapuram, AIR 2007, Supreme Court 794. Francis Stanley versus Intelligence Officer, Narcotic Control Bureau, Thiruvananthapuram. AIR 2007, Supreme Court 794. AIR 2007, Supreme Court 794. It said very clearly, evidence of an accomplice is looked upon with suspicion. I may write this. Evidence of an accomplice. It is written in our barrack also. Evidence of an accomplice is looked. I said in our barrack, not in all barrack. So please, if you have, if you do not possess our barrack, then you please write down. Evidence of an accomplice is looked upon with suspicion. With suspicion. Because to protect himself, he may be inclined to implicate the co-accused. You see the use of language, co-accused here. There is no substantial difference as such. Implicate the co-accused. It does not mean that the evidence of accomplice can never be relied upon. The rule of prudence requires that the evidence of accomplice should ordinarily should ordinarily be corroborated. I'll speak on corroboration as well by some other evidence. By some other evidence. By some other evidence. So what kind of corroboration is required? So there is hint again and again. If I start from that case which you might have read in case of child witness also, which was one of the most important case in child witness, that 1952 Supreme Court decision, if anybody knows, that was a very beautiful case and very important judgment of Justice Vivian Bose, one of the fundamental case on competency of child witness, Rameshwar versus State of Rajasthan, Rameshwar, no, versus State of Rajasthan, Kalyan Singh versus State of Rajasthan, that is. Now that case is important for many issues, child witness and accomplice evidence being two of them. Rameshwar Kalyan Singh versus State of Rajasthan, AIR 1952, Supreme Court, page 54. Rameshwar Kalyan Singh versus State of Rajasthan. AIR 1952, Supreme Court, page 54. In this Rameshwar Kalyan Singh versus State of Rajasthan, we discussed Justice Vivian Bose's decision and we talked about voir dire test on child's competency to be considered a witness and relevance of administering oath to child, and we said that child below is 12 is not required to be administered oath. Proviso is there now, so you have to take care of all those facts, but we are not on that point right now. We are discussing this accomplice evidence, and it says that accomplice evidence can be accepted. Accomplice evidence can be accepted. Accomplice evidence can be accepted. I am writing so that you can write also and you can make note as well. Accomplice evidence can be accepted if it is corroborated. If it is corroborated to some extent, at least on some material point. Accepted if it is corroborated. Obviously, if it is corroborated and corroborated on material particulars, corroboration is not required on all points. If corroboration is asked on all points, then what is the use of corroboration? Corroboration is support. So supporting evidence cannot be now on all points, otherwise it will be substituting evidence rather than supporting evidence. You just required to understand the words corroboration. It is not substitution. It says corroboration on certain material particulars. What material particular I will let you know. And in this case itself, the Supreme Court clarifies the point that 114 is presumption, mind you, where it is written that accomplice is unworthy of credit. So that is the question of credibility of that person, which is who is called accomplice. So it is basically talking of credibility of person. And 133 is on different aspect and it is in chapter 9. So this is talking of competency of witness. So credibility and competency should not be confused. And court further clarified on this point that see, presumption has a role only if there is no evidence as such. But if evidence has been produced by both sides, complete evidence from this side, from that side, so what is the role of presumption? What is the role of presumption then? Presumption has no role to play. Presumption has no role to play. You might have read that statement on presumption as well, that presumption may be looked on as the bats of law flitting in the twilight but disappearing in sunshine of actual facts. So if sunshine of actual facts have come, there is no question of presumption being there. It will evaporate. It will evaporate. So when actual facts have been proved before the court, what is the use of presumption? So just try to understand these nuances. It's very, very important. Rameshwar Kalyan Singh, birth state of Rajasthan. Court further said, in many cases, that there should be corroboration on some material particulars, material aspects. Material aspects. And that is 114B also says, if you can look to 114B, an accomplice is unworthy of credit unless is corroborated in material particulars. So material particulars have to be seen. Material particulars have to be seen. What are that material particulars can be? What can be material particulars? No corroboration is required on all points. So corroboration is required regarding the fact that there was commission of crime. There was commission of crime. And this person had some role in commission of crime. Had some role in commission of crime. कुछ ना कुछ तो इसने भी किया. Had some role in commission of crime. Commission of crime is one thing, and this particular person had a role in commission of crime, this is another thing. It should not be evidence of direct involvement, but it should be shown. It should not be evidence of direct involvement, but it should be shown that he had involvement in the crime. Direct, indirect, latent, patent, distant, present, whatever. Now, sometimes we say old cases are like gold in mine. So, old cases are like gold in mine. We are quoting very old cases, 1952 Supreme Court decision. Sarwan Singh versus State of Punjab, AIR 1957, 3-judge bench decision, Supreme Court 637. Following that Kalyan Singh case, again the court said that for accomplice evidence you are required to satisfy twin test, dual test. Twin test. Number one, he is a credible witness. He is a credible witness. He is a credible witness. And number two is deposition is also reliable. His deposition is also reliable. So credibility of person and credibility of version. There are two aspects to be looked into. Sarwan Singh versus State of Rajasthan. You might have read, and if you have not read, you just go and visit this case and you just see this. Court further said that apart from being reliable witness, his evidence must receive some corroboration. His evidence must receive some corroboration. His evidence must receive some corroboration. So only issue that he is credible is not sufficient. His evidence should also be credible. And there we require corroboration. Because we cannot rely upon his version, because 114b is also there. So you can understand it like this, that not only credible person, but credible evidence is also a requirement of law. I can see very clearly here written in the words of Supreme Court, his evidence must show that he is a reliable witness. That is a test which is common to all witnesses. If the witness is not reliable, not credible, will you accept his evidence? The answer is no. That is why there is provision in this cross-examination, examination, etc. to find out whether the witness is reliable, credible or not. To assess the veracity of his statement, we have this section 146, if I remember correctly. And there are many provisions. The whole method of cross-examination is to test his reliability, veracity. Now, furthermore, the court says, if this test is satisfied that he is reliable, then the second test still remains to be applied, is that the approver's evidence must receive sufficient corroboration. Otherwise, that evidence is not credible. Second test, approver's evidence must receive sufficient corroboration. Approver's evidence must receive sufficient corroboration. Must receive sufficient corroboration. The second test is special to cases of weak or tainted evidence. Weak or tainted evidence, like that of approver's evidence. Now, if you allow me to read this, Sarwan Singh versus State of Punjab, it has laid down the guidelines. So, Sarwan Singh case is very important, full bench judgment. Supreme Court said that though an accomplice is undoubtedly a competent witness under Indian Evidence Act, section 133 very clearly says, the very fact that he participated in commission of crime introduces a serious stain in his evidence, And courts are naturally reluctant to act on such tainted evidence unless it is corroborated in material particular by other independent evidence. However, one evidence, unless it is corroborated in material particular by other independent evidence, naturally reluctant to act on such tainted evidence introduces serious stain in his evidence, and courts are naturally reluctant to act on such tainted evidence unless it is corroborated in material particulars by other independent evidence. All right. However, one should not expect that such independent corroboration should cover the whole of prosecution story, no, or even all the material particulars, no. Such a view will render accomplice evidence wholly superfluous, and then that is of no use. If you seek support on all points, then what is the use of accomplice evidence? It can be supported on some points. If you support it on all material particulars, then it is a case of substitution rather than support. So it is not a corroboration, it is kind of substitution. I have said earlier as well. On the other hand, it will not be safe to act on the evidence merely because it is corroborated in minor particulars. Because in such a case, corroboration does not afford the necessary assurance that the main story disclosed by approver can reasonably and safely accepted as true. Supreme Court further clarified. Now, before you reach to the stage of corroboration, mind you, it's very important. First, you are required to decide the question of competency and credibility of the witness. So, competent witness 133 has clarified. That is a statutory provision. We cannot deviate. We are not allowed to deviate. As far as credibility is concerned, that you decide first. Credibility of accomplice. You decide first. First and essential question to consider is whether even an accomplice is a reliable witness or not. First, you decide that. Whether he is reliable or not. If he is not reliable, then what is the use of his byproduct? That is his evidence. His evidence must show that he is a reliable witness. Only when this question is satisfied, then the court will go into the question whether the evidence requires corroboration or not. Don't jump, don't hop. Many cases, Lachiram versus State 1967, Supreme Court again, I have quoted in my material too. The first test means that the court should find that there is nothing inherently improbable in the evidence given by the approver. There is nothing inherently improbable in the evidence given by the approver. And there is no finding that the approver has given false evidence. The second test which thereafter still remains to be applied, that in the case of approver and which is not always necessary when judging the evidence of the witness, is that his evidence must receive sufficient corroboration. So what I said earlier as twin test, the test of reliability and the test of corroboration. Reliability and corroboration are two wheels on which this chariot of accomplice evidence will run. So the test being talked again and again as twin test is the test of credibility of witness, that is accomplice witness, and the credibility of evidence which requires corroboration. So evidence of accomplice will require corroboration, and accomplice is required to be shown to be reliable witness. So these two things have to be satisfied again and again, then you can move further. It is not a new phenomena. Even in Privy Council decision Bhuvani Sahu versus King Emperor, this point was reiterated. So may I ask you first a question before moving further, that there can be corroboration of accomplice evidence by another accomplice evidence? See, there are certain fundamental rules. I said earlier, can you raise presumption on the basis of presumption? I said no. Presumption is always raised on the basis of foundational facts to be shown before the court, to be proved before the court. Similarly, this accomplice evidence cannot be corroborated by another accomplice evidence. No, 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 no. It has to be corroborated by other kind of evidence, not by accomplice evidence. No, 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 no. This is not mathematics. This is not mathematics. Now, there was an important question that whether confession of co-accused can be treated as corroboration of accomplice evidence. Confession of co-accused can be treated as corroboration of accomplice evidence. Privy Council said on this point that confession of co-accused is a weak type of evidence. Weak. Is a weak type of evidence. And this is not evidence under section 30 because it is not required to be given on oath. It is not required to be given on oath, nor in the presence of accused. So, other accused is also not available against whom you are talking. So, neither on oath nor in presence of the other accused on against whom you are speaking. So, the Privy Council said that this confession of co-accused is very weak type of evidence, very weak. So, accomplice evidence is far better than this. It is far better than this. Well, where you have oath of speaking the truth as well, and you are competent witness too. Then there are many cases in which other points have been said time and again. But I am very sure that whether, if you are asked a question, that what will be this evidentiary value of accomplice evidence, you should be very clear in your mind that the accomplice is a competent witness, but his evidence needs to be corroborated in material particulars, not in all particulars. Can there be corroboration of another accomplice evidence? The answer is no. Obviously, you have to satisfy the twin test. Don't mix the question of credibility and competency. And as far as the different issues raised by different courts are concerned, you can just have a glance. Various kind of questions have been raised in various cases. Like State versus B.C. Shukla 1980 decision of Supreme Court. They said testimony of accomplice cannot be accepted in any material particular in the absence of corroboration from reliable sources. Yes, you can say that. This is the rule of prudence. This is the rule of prudence. We don't mind it. Then furthermore, there has been observation that the law contained in section 133 is not a good law. Now, I can't say this. 133 talks of competency. And it only says that conviction is not illegal merely due to this reason, that there is uncorroborated testimony of accomplice evidence. I think the law is logical. That accomplice is a competent witness, no question about that. But as far as he is involved in the crime, he is not coming to the court with clean hands. Even if you see the civil law, equity says, one who seeks equity must come to the court with clean hands. This accomplice is not having clean hands. His character is questionable. His evidence is surely tainted. So it is rule of prudence and caution that it should be supported and it should be corroborated in material particulars. And that is what is the rule of caution in 114. And that is rule of presumption we have reiterated. And presumption evaporates when the actual sunshine of facts come there. So that is very clear law on the point. I don't find any confusion. Then there have been further observation of the court again and again that accomplice shall be a competent witness. Obviously, then he is unworthy of credit unless he is corroborated in material particulars. Yes, perfectly all right. And the further now observation of the court, these are the different questions raised in different cases as well. That the presumption can be dispensed with. Yes, if you prove the actual facts, presumption evaporates. I am saying this time and again. Can the court base conviction of an accused solely on the basis of testimony of accomplice? Generally speaking, no. But there cannot be now law. Law is social science, and I remember that statement, happy are those nations where law is not treated as mathematics. So don't make it mathematics. But generally speaking, no. Cannot be the sole basis of conviction. But obviously with this word of caution that I cannot propound a mathematical absolute rule in a case. Because see, 133 is very clear. It says conviction is not illegal merely due to this reason that there is uncorroborated testimony of accomplice. Now, why Stephen wrote that? There is a reason behind that. There can be no unusual, rare case where accomplice evidence may be relied upon. He is man of great character. He may be Gandhi. Anybody can commit crime, may be involved in the crime somewhere, and he is Gandhi. So obviously you can rely upon his testimony. How can I say that his testimony is to be doubted? So with this observation, I think I have answered all the questions related to accomplice.